Hey guys, today we're going to talk about the corporate veil. What is the corporate veil? It is a legal concept which state that a company is a separate legal entity from the directors and shareholders. This was laid down in the famous English case of Solomon and Solomon. This legal concept separates the actions of a company from the directors and shareholders, so it protects them from being liable for the company's actions and company's liabilities and debts. Only in very exceptional circumstances, the court will ignore this separate legal entity concept and look behind the corporate veil at the shareholders or the controllers of the company. This is called piercing the corporate veil or lifting the corporate veil. And the court, when they lift the corporate veil, they will hold the company's investors or directors personally liable for the company's activities, the wrongs, or the debts. When will the corporate veil be pierced? Where the company was set up to evade legal obligations or to commit fraud, the court will not allow a company to be used as a cloak or to disguise a fraud, or to allow a person to evade his legal obligations. Number two, where the company employed as an agent for its shareholders or controllers based on general agency principles. The principal is liable for the acts of the agent. In this case, the company is being an agent for its shareholders or controller. Number three, where the company is used as a sham or facade. For example, when a person uses the company as an extension of himself and makes no distinction between the company's business, the company's assets, or his own. For example, in the case of Children's Media Limited and Singapore Tourism Board, the court held that the companies were used as a facade and sham to siphon off money for the controller of the company, the main shareholder. So the court lifted the corporate veil and made the shareholder, the controller, personally liable for the debts owing to the company. The court found that the two companies were no more than corporate puppets, compliantly dancing to the tune of their common controller, and that the controller treated the company's assets as his own personal assets. Therefore, on that basis, the court lifted the corporate veil. Fourth reason where the court will lift the corporate veil, when it is just in the circumstances to do so. This is a residuary general discretion retained by the courts and exercised whenever the justice of a particular case requires. Simply put, the eyes of equity will not be blinded by any corporate mask that a person may hold before his face to shield himself. This was mentioned in the case of Jones and Littman. So in other words, the courts will not allow a person to use the company as a mask to shield his obligations. There are certain provisions in the Companies Act that make the officers, the directors or shareholders personally liable. For example, Section 3393 of the Companies Act states that where there is evidence to show that the officer, which includes directors, contracted a debt on behalf of the company and he had no reasonable or probable expectation that the company would be able to repay the debt, the director will be personally responsible for the debt. Section 340 of the Companies Act also provides that where the business of the company has been carried on with the intent to defraud creditors, that means people who are chasing the company for money, or for a fraudulent purpose, the aggrieved party may apply to the court for a declaration that any person who was knowingly a party to the carrying on of the business in that manner, that fraudulent manner, be personally liable for the debts of the company. Section 403, subsection 2b of the Companies Act also provides that if a director of a company willfully, that means purposely, pays or permits the payment of a dividend to the shareholders where there are no available profits, he will be personally liable to the creditors of the company for the amount of the debts owed to the creditors to the extent by which the dividends exceed the available profits. As some of you may be aware, dividends can only be paid out of profits. So if there are no profits, you cannot pay out dividends to shareholders. And if you pay out dividends to shareholders where there are no profits, the directors will be liable for the shortfall. So thanks for watching this video on the corporate veil.